What is next for the prosecution of Nicolás Maduro, the former leader of Venezuela, now in U.S. custody and facing charges in the American justice system? The Hill's Zach Schoenfeld joins us to discuss. This week in the Gavel, which is your newsletter covering the courts and legal issues, you write about this issue of immunity. Would Maduro have an argument for immunity as the former head of state?
Hey, Drew. Well, legal experts who I have been hearing from ever since this extraordinary operation over the weekend in Venezuela, they believe that is going to be one of Maduro's big defenses here ahead of his potential trial in New York City, making this argument that as a foreign head of state, he has immunity. And it is true that under long-standing principles of international law that have been abided by here in the U.S., that foreign heads of states cannot be brought in and be prosecuted. However, the key issue here for Maduro is going to be the fact, of course, that the Trump administration doesn't recognize him as Venezuela's legitimate leader following the recent elections there. And so you can expect the Trump administration and the Justice Department, the argument that they're going to try to make to this judge is saying that he's not a foreign head of state. And so because of that, this whole doctrine of immunity doesn't even apply in the first place. This is a similar dynamic to what we saw play out after the U.S. invaded Panama back in 1989 and deposed the military ruler at the time. And there he came to the U.S. to face drug charges, very similar to what we're now seeing play out with Maduro. And in that case, too, the Panamanian leader had made this claim of immunity, but the judges in that case back in the 1990s rejected it because of the fact that by saying that he wasn't recognized as Panama's true leader. Now, those cases aren't completely synonymous to Maduro here. One key difference will be the fact that that Panamanian general never actually held the title of president. Of course, Maduro has purported to hold the title of Venezuelan president. So there are some differences, but there's been precedent for this before, Drew, of where we've seen these foreign heads of state come into the U.S. and be prosecuted and brought all the way through trial and convicted.
And Zach, tell us about the Keir-Frisbee doctrine and how that plays into the Maduro case.
Yeah, this Keir-Frisbee doctrine, a little bit of legal jargon, but it is one that really could come into play here. You know, as I talked to some of my friends, following this operation in Venezuela, one of the things that they asked me is about the extraordinary circumstances of that operation. There, of course, have been questions about whether it was constitutional. Did President Trump need to either brief Congress or even get congressional authorization? And so I've been fielding texts from some of my friends, asking me, are the courts going to get involved in this? And that is where this doctrine comes into play, because this doctrine says that when a situation like this, where you have a foreign defendant, where the U.S. has gone in a military operation to a foreign country, taken a foreign leader, brought them back to the United States for criminal prosecution, that just by the fact that Maduro is now back off the USS Iwo Jima back in New York, that's enough. The courts now have jurisdiction. In other words, he can't start making claims that actually what happened there on the ground in that compound back in Venezuela, that was somehow an illegal arrest, or he was essentially abducted. There is long-standing doctrine on the books, Drew, that says that doesn't matter to the courts. They have jurisdiction. Now, as we've been talking about, Maduro has some potential other defenses that he can try to raise pre-trial, but at least on this front, it seems that it's not going to be an issue for the courts.
I want to switch gears and talk to you about National Guard deployments. President Trump says he's pulling back troops, comes after this ruling from the Supreme Court, but Trump says that they could return to cities if crime spikes. What is the latest on National Guard deployments, and what limitations has the Supreme Court now placed on President Trump?
Yeah, Drew, quite an announcement from the president following the Supreme Court ruling. The case that had gotten up to the Supreme Court, of course, there have been cases in these blue cities all across the country, but the case that got up to the Supreme Court was the case involving the National Guard deployment in the Chicago area and Illinois, and the Supreme Court actually ruling against President Trump, one of the only times that we have seen the president lose on the Supreme Court's emergency docket since he has taken office. And because of that, that was a massive loss for the administration. Not only, directly, that decision prohibited them from deploying the National Guard in Chicago, but as I said before, there are very similar cases playing out in other cities too, places like Portland. Even here in the nation's capital in Washington, D.C., there's been a legal battle, although because of D.C.'s unique status, there's a bit of different legal issues there. And now you have this announcement from the president that he's not going to keep trying to deploy the National Guard in some of these cities. But as Drew, as you mentioned there, he did leave the door open if crime spikes or something else happens, that he could bring the troops back in. So it does seem that one chapter of this National Guard story, at least in some of these cities, is coming to a close, but might not be the end of the story. We'll just have to wait and see.
All right, last question I want to run by you. As 2025 came to a close, we did get some data from the federal judiciary's caseload. One thing that popped out to me was that criminal cases increased by 13%. Seems like a pretty significant jump. Why is that?
Yeah, Drew, a pretty significant jump there, 13%. And just want to go one layer deeper beneath that top line number to answer that question of why. And that is immigration cases. Immigration cases have long made up the bulk of the criminal docket. To give you an idea, there's about 32,000 immigration cases. It is the largest category of federal offenses every year. But to give you an idea, you just moments ago said the overall criminal jump, that was 13%. But if you only look at immigration criminal cases, that jumped by 27%. So you can explain a lot of this increase in criminal cases in fiscal year 2025 by this increase in immigration cases. And of course, this comes as President Trump came back into office. His administration has pursued a very aggressive immigration agenda, including many of these cases that have landed in the courts. These criminal immigration cases involve people who are accused of unlawfully entering the country, of visa misuse, things of that nature. So it really was that immigration increase that really drove the increase in criminal cases. To give you an idea, the second biggest category is drugs. Those cases actually fell by about 6%, where most of the other categories, for the most part, remained at least relatively flat. So it's that immigration piece, really interesting here, Drew, that is putting up the numbers for criminal cases. Also, just to give you a sense of other aspects of the docket, bankruptcies increased last fiscal year. Also, civil cases, when you take out some of the multi-district litigation cases going on throughout the country, those increased as well. So some big increases here for some parts of the federal judiciary's caseload. Drew?
All right, Zach Schoenfeld, always great to have insight from your newsletter. And if people want to get it delivered to their inbox, head over to thehill.com, click on newsletters, go on down to the Gavel, and have it sent right to your email inbox. Zach Schoenfeld, thanks for your time.
Thank you.